But let us go to Jenna Ellis. She is, I shouldn't have to introduce her anymore, but I do it just for my own personal pleasure. She's the director of the Dobson Policy Center, a contributor to the Washington Examiner, the Federalist, and our own Daily Wire. Her book is The Legal Basis for a Moral Constitution, a guide for Christians to understand America's current constitutional crisis. Jenna, it's been, I don't know, days. It's great to see you.
Great to see you too. And I'm loving the Ted Cruz beard. You're rocking it.
Do you like it? I'm getting a little. Yeah. All right. Well, that's it.
I mean, you're in this season, and with everyone and all the liberals who love Ted Cruz's beards now, maybe they'll start tuning in and they'll love you too.
I think it would take more than a beard, but I'll hope so.
Start there.
I'll live in hope. So I wanted to talk to you. I mean, there's been a bunch of things happening at the Supreme Court level that I just think are really interesting. And the first one, I believe it was just one Planned Parenthood case. Correct me if I'm wrong.
Three.
It was three. All right. So I thought so. It was more than one. So it's three cases that the court refused to hear, and Gorsuch and Kavanaugh actually agreed with that sentiment. So could you give us like an outline of what the cases were and what they were looking for?
Yeah, so the issue here, although Planned Parenthood was involved in a sense, the issue was whether or not a Medicaid recipient had a private right of action to challenge a state's decision to defund Planned Parenthood. So that we're dealing with a civil case. We're not dealing directly with a question of abortion. And the main thing that we need to take away from this is that the very same docket, I actually went and looked at it. There was one case that was granted for cert on that same day for review. There were 12 pages of denials of cases. This is nothing out of the ordinary for the Supreme Court. And so for conservatives and the extreme right that, of course, want the court to hear abortion cases, we want to see a conservative majority overturn Planned Parenthood versus Casey. These particular cases, because of the issue in question, does not give an indication any way whatsoever what Justice Kavanaugh, Justice Roberts, and the now conservative majority may end up holding on an abortion actual issue.
So the case was that the state wanted to defund the Planned Parenthood in its state, and they weren't allowed to do that. Is that fair?
The challenge, and so there's a diversity of opinion, and that's really why Justice Thomas wrote a very scathing dissent, because there's a split in the circuits of saying whether or not a private individual, let's say you or I, are Medicaid recipients, and we get services based on Medicaid from Planned Parenthood. If a state decides we are not going to allow Planned Parenthood based on selling fetal tissue, based on abortion, based on whatever reason, they are not qualified Medicaid providers, then I, as a Medicaid recipient, am going to challenge my state decision to defund Planned Parenthood because I now, as a Medicaid recipient, can't go to them for other Medicaid services. So that's the question, and there's a split among the circuits. And so I think that we're going to see this particular issue go back before the Supreme Court. It may just be that the justices want to see this issue kind of fleshed out a little more before they take up the issue. And I don't think that this signals anything about their unwillingness to address it overall, just that they didn't choose to address it now on these particular cases.
So there was a lot of tea leaf reading over this about this means that basically Gorsuch and Kavanaugh are going to stand up for Roe v. Wade, are going to not overturn Roe v. Wade, but you don't see that at all.
Well, it would be Roberts and Kavanaugh. So so Gorsuch, Alito, and Thomas all voted to take up the cases and as three, and everyone was hoping that Kavanaugh would be the fourth vote, and he wasn't. And so now there is a lot of tea leaf reading saying, oh, this is somehow some kind of prediction on a substantive abortion issue, but we have to differentiate and say this is the judicial process. This in no way indicates anything one way or another. I don't think that Planned Parenthood can claim victory in the sense that they were once these cases were declined. And I don't think that conservatives need to panic at this juncture either.
Fair enough. Okay, good. I was interested in that. You see these headlines flash by, and I don't always have a chance to follow it down to the ground. But that's really interesting. Now, just to stick on the question of abortion for a minute, there's a law in Ohio that you were writing about where basically they've outlawed abortion. It seemed like to me. Is that fair?
Yes, that, and so there will be a piece up hopefully later today in Daily Wire that is talking about the Ohio heartbeat bill and what this will do. And this is now passed out of both chambers, will go to Governor Kasich's desk. And what it is essentially saying that an abortion, when a woman comes in for an abortion, then they have to do an abdominal ultrasound. And if a fetal heartbeat can be detected, then abortion services are not eligible at that stage. So this would protect life as early as 5 to 6 weeks. And also the other component of the bill is that the Ohio State Medical Board could actually punish and have sanctions against medical practitioners, even if there's not a criminal conviction that goes against the law. So this is really the most comprehensive and really sound pro-life legislation that we've seen coming out of a state in a while. Similar legislation was passed in 2016. Kasich vetoed it. He's saying that he's going to veto this one, but he's going to wait until the last minute so that the Ohio legislature will have a really hard time with a veto override. So we'll see what happens. There's a lot of conservative policy groups. Dr. Dobson here at the JDFI, the James Dobson Family Institute in particular, we are urging Governor Kasich to make this his legacy and sign the bill to protect life, not only because it's constitutional, and that's clearly what the legislature is intending, but also because we know from ultrasounds, we know from all of the medical evidence, these are human babies that deserve protection.
You know, just to engage in a little bit of fantasy, let's say Kasich did sign it, and it would obviously be challenged right away. It would never survive Roe v. Wade, would it?
Well, this is the exact type of legislation that could go up to the Supreme Court on a challenge that would give the new conservative majority the opportunity to overturn Planned Parenthood versus Casey and Roe versus Wade, because what they can do just as a procedural question, and I've written for Daily Wire on this subject as well, they could say this is not at all the within the federal government's authority, and certainly not the Supreme Court, to tell the state how they can regulate abortion. So regardless of whether or not we personally agree or disagree with abortion as a policy issue, it is not for the federal government to mandate to the states how they determine healthcare policy. So that's really the easiest way that the Supreme Court can overturn the current abortion opinions.
That's really interesting, because I think that's, to me, that's always been one of the worst, well, aside from the abortions, that's always been one of the worst parts of Roe v. Wade, is that it's overreach of federal power. Is there any argument, every time there's a justice up for confirmation, they're constantly talking to him about precedent and super precedent, and whether or not Roe v. Wade is protected by the fact that it has been confirmed several times in decisions? Is there any argument where precedent somehow becomes more important than what it actually says in the Constitution? In other words, is there some sense in which Roe v. Wade is protected simply by the fact that it's been confirmed several times in other decisions?
Not at all. And that's a great question, because there's no such thing as super precedent. All due respect to Dianne Feinstein, that's just not a thing that's in the Constitution. But if you look at Article 3 and the role of the judiciary, they are under the Constitution. And so they have to determine law and policy and whether or not that actually is either conflicting or it abides by the Constitution. So the Constitution is the supreme law of the land. And so even if courts have gotten it wrong for 50 and 60 years or even longer, it's the obligation of the Supreme Court to go back and say, the court, we previously have gotten it wrong, we are going to change that. And I think it's very interesting, Drew, that even before Anthony Kennedy retired, we saw the Supreme Court shift back toward this federalist model of saying we've gotten it wrong in cases like Murphy versus NCAA, Janus, the union worker decision, where they actually contemplated these types of federalist questions and said, even though there have been laws on the books and opinions since, the early 70s, we are now going to say those were unconstitutional, it was an overreach, and we're going to give these issues back to the states because that's properly constitutional.
If you had to guess, would you think Kavanaugh would be a vote against Roe?
If I had to guess, I would think that from a strictly originalist perspective, regardless of his own personal policy, I think that he will be a vote to overturn Planned Parenthood versus Casey and Roe because of the constitutional questions involved. And I think that his 12 years of opinions on the DC Circuit show that he is an originalist and he will be faithful to the Constitution, even over his own personal policy, if he's personally, and we don't know, if he's personally a supporter of abortion.
Fair enough. All right. Now, to move on to something else that is just a personal hobby horse of mine, this case, Kisor versus Wilkie, is kind of an obscure little case, but it actually brings up something that really bothers me, which is this kind of almighty power that has been given to regulatory agencies to basically decide what the law means for themselves, and they can virtually not be questioned. Can you explain what this case is and what it means?
Yeah, you and Justice Gorsuch are really big fans of
one of the reasons I like the guy, yeah.
I know, right? So, and he's from Colorado, so yay, Justice Gorsuch. But yeah, so basically, this deals with a complex legal doctrine that's called Chevron deference, which is Chevron was a party to the case where this doctrine arose from, and so that's where a lot of the legal doctrines are named simply because of the parties. So Chevron deference is this idea that if Congress does not explicitly address a question in a statute, then whatever administrative authority they give to an executive agency, then the executive can basically interpret it and implement it any way that it wants, as long as it's reasonable. And so then the courts aren't going to second guess the agency if Congress hasn't spoken. So you have a twofold problem where the court is saying, we're not going to override the agency's decision, but they're not putting the onus back on Congress. And Congress really needs to step up and say, wait a second, there is way too much administrative prerogative going on to basically be their own interpretation of the law. And as long as they view themselves as reasonable, then they can go ahead and act according to the statutes any way that they want. So this particular case, and this was the one case that this past Monday was actually granted for review, this gives an opportunity for the court to really roll back the administrative state and say, we are going to roll back Chevron and some of the other outflowing cases, say the administrative state has gotten way too large. This goes completely against the separation of powers and the legislative authority of Congress. But really, even if they do that, Drew, Congress needs to step up. And how much do we say that on so many different issues? But Congress really needs to step up, and they need to legislate much more explicitly so that we don't have this crazy grant of just humongous authority to the administrative state and executive agency.
Well, it's kind of a double bind, because by giving this much power to regulatory agencies, Congress gets off the hook for its own decisions. They can blame the regulatory agencies for the things that they do without saying and say it's not in the law. This is just what they did. But at the same time, it encourages them not to pass laws, not to do anything, because they can depend on the regulatory state to do it. It's actually a collapse. It threatens a collapse of democratic legislation, I think.
Yeah, and it threatens the collapse of separation of powers. We have separation of powers for a reason, so that we have a legislative branch and then we have an executive that cannot legislate. And so as a practical example for people who may be thinking this is getting in the weeds a little bit, look at the immigration decisions. And so because Congress, through legislation, abdicated so much of their immigration authority to the executive, and President Trump rightly cited his ability to close the borders or to deny entry, that really needs to fall under Congress, and they specifically have immigration authority under Article 1, Section 8, but they're unwilling to do that because they can't get it together to pass common sense legislation on that. So they're saying, you know what, executive, why don't you do this? You have border control, you have INS, you have all of these regulatory agencies, you do it. And sorry, my eye is watering for some reason. I promise it's not because I'm not crying over your beard. I promise.
That's good to know. Yeah.
Yeah, I know. And so with the immigration issue, I mean, it's that with the trade, the TPA authority, with all of these things that Congress has legislated, basically saying we're just giving this to the executive branch. They can determine what they want to do. Then Congress sits back and says, hey, not our fault.
It is an amazing system. It's like a catch-22 where they never have to do anything. And really, it seems like only the courts can get us out of it at this point, or at least for now. Jenna, it's always great to see you, and I probably won't see you before Christmas, so have a Merry Christmas.
Merry Christmas, Drew. Always great to be with you. Thanks.
All right, talk to you soon. Bye.